to switch on their cameras.
Good morning, sirs. We are happy to have you all today.
Good morning, Mana. Good morning.
Basava, sir, we also have Deepak Bhattacharjee, sir, today.
Good morning, Mr. Bhattacharjee.
Good morning. Good morning.
Courtmaster, you all can start the session.
Good morning, everyone. I am Vijayalakshmi, your Courtmaster 1, and that is Akshaya, your Courtmaster 2. On behalf of Thomas George and Associates, I cordially welcome you to the 4th National Virtual Moot Court Competition.
We are pleased to extend a warm welcome to Mr. Advocate Deepak Bhattacharjee and Advocate Basava Prabhu Patil. A brief intro of both the judges I would like to give. Mr. Deepak Bhattacharjee did his LLB and LLM in Constitutional Law from the University of Osmania. He enrolled as a lawyer in year 1981. He joined the office of late Upendralal Vagrai and thereafter started his independent practice in the year 1983 and became a panel advocate of Canara Bank, Syndicate Bank, SBI in the same year. Later, he was also empaneled by several renowned banks. He was appointed as standing counsel of numerous esteemed universities and institutes. Mr. Bhattacharjee was also designated as senior advocate by High Court of Andhra Pradesh in the year 2016. More than 400 judgments in which he appeared as a counsel are reported in law journals. He is now regularly engaged as senior advocate in High Court of Telangana, High Court of Andhra Pradesh, Supreme Court of India, NCLT, NCLAT, DRT, DRAT by various law firms and body corporates. Coming to Advocate Basava Prabhu Patil, Advocate Basava Prabhu Patil is a senior advocate practicing in the Supreme Court of India. He is also the Advocate General in the state of Sikkim, a lawyer with 3 decades of practice. He has made over 25,000 appearances before various forums, including high courts, commissions, and appellate tribunals, besides having represented his clients in domestic and international arbitrations. His field of law practice is diverse and includes constitution, criminal, electricity, matrimonial, and various other fields. He is an alumnus of University Law College, Bengaluru, and was the first to graduate and enroll from its 5-year law course in 1991. He was designated as senior advocate by the Karnataka High Court at the age of 39. Mr. Patil has been conferred with National Bar Award in 2009 in recognition of his dedication to the study and practice of civil law, and the 40th Annual Aryabhatta International Award in 2014 in recognition of his service in the field of law. He is also on board of Examiners, Supreme Court of India for advocates on record examination and a distinguished visiting faculty at his alma mater, the University Law College. We'll now proceed to explain the time division granted to each counsel in a single team.
So each team is allocated 30 minutes to present their case. Each speaker will get 15 minutes unless indicated otherwise by the team. Placards showing 5 minutes over, 3 minutes over, and time up will be displayed. Rebuttals are left to the discretion of judges. Sir, do we start with the rounds?
Yes, you can start.
Thank you, sir. I would like for the participants to please start the rounds.
Greetings, your lordships. Hope the council is both visible and audible, your lordships.
Yes.
Much obliged, your lordship. This is the council appearing on behalf of the petitioner under Article 32 of the Constitution of Indigo through public interest litigation in the case of Jan Seva versus Republic of Indigo. Would your lordships appreciate brief perusal of the facts?
Yes.
Much obliged, your lordships. The Republic of Indigo is accustomed to the doctrine of separation of powers, wherein legislature, executive, and judiciary has its own peculiar functions. Legislature is assigned with the task of making laws and is comprised of members of parliament and members of legislative assembly who are elected indirectly and directly, respectively, your lordship. These elected MP and MLA can be disqualified from their office through Article 102 and 191 of the Constitution, respectively. Under Clause 2 of the above said article, MP and MLA can be disqualified based on the 10th schedule of the Constitution, your lordship. Anti-defection law, which is discussed in the 10th schedule, was initially passed in a private member bill by Sri T. Venkata Subbaiah in 1967. After analyzing Chauvin Committee and other committee reports, through 52nd Amendment Act 1985, anti-defection law was introduced, which has certain loopholes, and the constitutionality of the same has been challenged by the NGO named Janseva, your lordship. If your lordship is satisfied with the facts, may I move to the issues in the hand, your lordship?
Yes.
Yes.
Much obliged, your lordships. There are 4 issues in the hand, your lordship, which deals with maintainability, validity of provisions of anti-defection law, and the roles and powers of speaker in relation to disqualification and the existing alternative measures to curb defection, your lordship. The first 2 issues will be handled by myself for 16 minutes, and the third and fourth issue will be handled by my co-counsel in 14 minutes, your lordship. If your lordship permits, the council would like to reserve last 2 minutes for the rebuttals, your lordship.
Sure.
Much obliged, your lordship. If your lordship permits, may I proceed with the first issue, your lordship?
Yes, go ahead.
Much obliged, your lordship. First issue, whether the public interest litigation filed before this honorable court is maintainable. The council most humbly submits that the public interest litigation filed under Article 32 of Constitution of Indigo before this honorable Supreme Court is maintainable. This can be contended with the help of 3 essentials, your lordship. First, sufficient cause of action. Second, derogation of fundamental rights. Third, substantial involvement of public interest. First, sufficient cause of action.
Counsel, just a moment.
Much
But with all these 3 facets, can't you not file it before the High Court?
Yes, your lordship. But in the case of Harbin Shell, Sahania and others versus Indian Oil Corporation Limited, it has been stated that alternative remedy is not a bar to approach Supreme Court in 3 contentions, your lordship. The first one is enforcement of a fundamental right, your lordship. Second, failure of principles of natural justice. And third, where the orders of proceedings are wholly without jurisdiction, your lordship. In this case, the first point, that is the enforcement of fundamental right, is being engaged in the present case. We have approached the Supreme Court for the justice, your lordship.
But are the same grounds not available to you in the High Court? Fundamental rights, cause of action, each one of the 3 which you said, they are all available if you can move the High Court. It's not an alternate remedy, it's a parallel remedy.
Much obliged, your lordship. But since the fundamental right of an individual is of much importance, we have approached the Supreme Court where we can get speedy remedy, your lordship.
The Supreme Court is has more time than the High Court.
Not indeed, your lordship. But still, the council like to reiterate the point that Supreme Court will give the remedy within time and will be more appropriate, your lordship.
But the powers of the High Court under Article 226 is much wider than Article 32 of the Constitution.
Yes, your lordship, but here the fundamental right, that is Article 19 Clause 1A, is of much importance for an individual, your lordship. This has been violated in the case of in the present case, your lordship. Therefore, the council has sought the Supreme Court, your lordship.
Okay.
Much obliged, your lordship. So, in the sufficient cause of action, in the famous case of Kusum Ingots and Alloy Limited versus Union of India, it was held that the writ court cannot determine constitutional question in a vacuum, which means the court can question the validity of an act only when it gives rise to civil or evil consequences when it is implemented, your lordship. In the present factual matrix, the hasty and delayed decisions of the speaker, uncertainty of time period, and directions imposed by the political party are considered as some evil and civil consequences, which can be explicitly seen in the Maharashtra political crisis and other states, Your Lordship. And these are the negative after effects which are considered as cause of action in the present case, Your Lordship. And the second and third essential has a cause and effect relationship where derogation of fundamental right leads to substantial involvement of public interest, Your Lordship. This can be dealt in the respective dimension where defiance of political whip is used as a ground for disqualification, which violates Article 19 Clause 1 subclause A of Constitution, which talks about right to freedom of speech and expression. This aspect of legislative member is pertained and provided under Article 105 and Article 194 of the Constitution for MP and MLA respectively, Your Lordship. In the present factual matrix, the violation of fundamental right can be seen in instances where elected members are forced to act as political party member rather than the representatives of the people, Your Lordship. And
Council,
much obliged, Your Lordship.
council right to contest is a fundamental right or a statutory right?
Your Lordship, in the Jyoti Basu versus Debi Ghoshal, it was stated as statutory right, Your Lordship. But after it was reversed in the case of Anup Baranwal versus Union of India Ministry of Law and Justice Secretary 2023, it was stated that it is a part of fundamental right, Your Lordship.
Right to contest an election.
Yes, Your Lordship. Much obliged, Your Lordship. And it is also pertinent to note that in the democratic form of government, MP and MLA are the representatives of the people of his constituency in the highest lawmaking bodies in the center and state respectively, as stated in P.V. Narasimha Rao versus State 1998. The freedom of these individuals under Article 105 and 194 is to be construed in a much wider sense or equivalent to Article 19 Clause 1 subclause A, as they are the ultimate voices of the people, which attracts public interest, Your Lordship. The council...
What happens to 19.2?
Much obliged, Your Lordship. The council would beg to differ from the point, Your Lordship. Clause 19 Clause 2 is the reasonable restriction, but in no way restriction or curbing the right to freedom of speech can be considered as a proportional or reasonable restriction, Your Lordship. Much obliged, Your Lordship. The council would also like to reiterate the point that right to elect has been considered as a part of fundamental right, as I earlier stated. And in addition to that, the misuse of doctrine of merger by small legislature party and the partisan acts of speaker in legislation to disqualification owes to the infringement of rights of the representative as well as the public, Your Lordship. And the council would like to refer to the PIL guidelines. If Your Lordship permits, my co-counsel will share the screen, Your Lordship.
Yes.
Much obliged, Your Lordship. The council would like to refer to the PIL guidelines, where the subject matter of the present case falls under the ground of other matters of public importance, Your Lordship. Therefore, it is most reverently submitted that the public interest litigation filed under Article 32 is maintainable as it satisfies the essentials of public interest litigation, Your Lordship. If Your Lordships are satisfied with the first issue, may I move to the second issue, Your Lordship?
Sure.
Much obliged, Your Lordships. Whether the anti-defection law is violative of basic structure of Constitution and deviated from its purpose. The Council most respectfully submits that the constitutionality of a legislation can be questioned and declared unconstitutional on 3 grounds as listed in Namit Sharma versus Union of India 2012 case, where legislation can be considered as unconstitutional when the legislation is incomplete, when it violates the fundamental right and reasonableness of law. Since point 2 and 3 stands satiated in the present case, anti-defection law is to be declared unconstitutional, Your Lordship. This can be elucidated through 2 main heads and with subsequent test of morality and proportionality, Your Lordship. Head A, political whip as a ground for disqualification. Para 2, Clause 1, Subclause B of the 10th schedule deals with political whip as a ground for disqualification, where an elected member abstains himself from voting or voting in favor of his political party. This concept of political whip clutches the representative and suppress their individual autonomy or conscience and forcing them to abide by the directions of political party, which makes them as a mere pawn in the hands of political party, your lordship. And the scope of expression any direction is to be literally construed. Otherwise, it would make the people's representative wholly a political party representative, which decidedly he is not. If it happens the otherwise, the members would virtually lose his identity and would become a rubber stand in the hands of political party, as well established in the case of Prakash Singh Badal versus Union of India 1987. And it is also pertinent to note that Dinesh Goswami committee has stated certain instances when a political whip can be issued, your lordship. That is when there is motion of vote of confidence or motion of no confidence and so on. But in the present era, political whip has gained much wider scope and is issued in matters apart from the above listed ones, which ultimately curtails the rights of MP and MLA by not allowing them to act according to the welfare of the people, your lordship. And in addition to this, the council would like to refer to the 178th Law Commission report, which stated that leaving no room for dissent subsequently puts an end to the freedom of speech, which is so essential for the functioning of democracy and parliament and legislature, your lordship. Hence, the council pleads the unconstitutionality of the provision para 2 clause 1 subclause B of the 10th schedule. Head B. Para 4 as a ground for disqualification. It is most respectfully brought to the notice of this honorable court that there exist certain exceptions to the defection done by the political representatives. Political split and political merger, as dealt in para 3 and para 4 of the 10th schedule respectively, are the two exceptions, your lordship, where for a valid political split, consent of 1/3 of the members of such political party is essential, and this essential and requirement was misused to escape from the disqualification under defection. Therefore, in the 91st Amendment Act, it was removed, your lordship. In a similar way, for a valid political merger, 2/3 of the majority of political members of the political party must give consent for the same. And its constitutional validity has been challenged in 178th Law Commission report and also recommended to remove the para 4, just like it was done for para 3, your lordship. And the council would also like to give emphasis on the fact there are 3 tests to check the exceptions, your lordship. That is, first one, test of numerical majority. Second, test of aims and object. Third, test of party constitution, which is listed out in Sadiq Ali versus Election Commission of India 1972 case, your lordship. And it is also stated that the test of numerical majority is the most probable and valuable test, and that it has been applied all over India, your lordship. But there arises a loophole called deemed merger, your lordship, which is used as a tool by the small legislature party to escape from the disqualification. As defined in the Subhash Desai versus Principal Secretary Governor of Maharashtra case, original political party is the party which constitutes all the members of the party, and legislature party is the party which constitutes only the elected members of the original political party. When it comes to this context, the decisions taken by the members of the legislature party are considered as the decisions of original political party in the House, your lordship. Therefore, when the test of numerical majority is applied to check the validity of the merger, the small legislature party misuses its representation on behalf of the original political party to escape from disqualification, which is to be termed as deemed merger, your lordships. If your lordship permits, the council would take this as an honor to illustrate this deemed merger, your lordship.
Yes.
Much obliged, your lordship. Let us presume that there is an original political party named A and consider the legislature party of A as B, your lordship, which constitutes merely 3 members. In the present factual matrix, 2 out of these 3 members wishes to form political merger with another political merger, original political party called C. all these three members of the legislature party are the representatives of original political party A. Therefore, irrespective of whether an actual merger has taken place between the original political party or not, the protection under the exception rule is available to the two legislative party members whose intention was profit motive and lure of office, your lordship. So this is how the exception is misused by the small legislature party. Hence, the council pleads that the para should be declared as unconstitutional in two bases. That is, usage of merger as a means of evading disqualification, and two, difficulties in determination of original faction of the then merged party, your lordship. And the third contention is that both the provisions fails to satisfy the test of constitutional morality and proportionality, your lordship. It is well established in the case of Navtej Singh Johar versus Union of India 2018 that the preambular goals of our constitution, which contain the noble objectives such as justice, liberty, equality, and fraternity, can only be achieved through the commitment and loyalty of the organs of the state to the principle of constitutional morality. But in the present factual matrix, the various facets of anti-defection law, such as imposition of direction, unchecked power of speaker, inability to curtail merger based on unprincipled means and lure of office, stands vitiated of the constitutional morality, your lordship. And in addition to this, the doctrine of proportionality, that is, the administrative action taken to protect one's right, must not be drastic than the desired outcome, your lordship. Though the 10th schedule is considered to be an administrative action entrusted upon the speaker, it drastically curtails the liberty of the representative beyond reasonableness when they defy political whip, your lordship. Therefore, it is most humbly submitted that the anti-defection law is highly ultra-virus of the Constitution of Indigo for the above-mentioned reasons, your lordship. If your lordships are satisfied with the second issue,
Yes.
much obliged to your lordship. The council takes this as an honor arguing before your lordships. May I leave the podium to my co-counsel, your lordship?
Just before you sign off,
Yes, your
one question. Where do you get this concepts of basic structure and constitutional morality?
From the Kesavananda Bharati versus State of Kerala, your lordship.
From the constitution, where do you get them? Is it a judge-evolved jurisprudence?
Much obliged to your lordship. These principles have been laid in a plethora of cases, your lordship. From all these cases of Supreme Court, we have obtained this principles, your lordship.
Oh.
Much obliged to your lordship.
Greetings, your lordship. Hope the council is both audible and visible.
Yes.
Much obliged, your lordship. Your lordship, the council will be dealing with issue 3 and 4, your lordship. To begin with issue 3, Article 93 deals with the Speaker and Deputy Speaker of Lok Sabha, and Article 178 deals with the Speaker and Deputy Speaker of the Legislative Assembly, your lordship. Now, the council would like to share the screen to portray some documents, your lordship. Much obliged, your lordship.
First, tell us what's the point that you want to make.
Yes, your lordship. Your lordship, para 6 clause 1 of the 10th schedule deals with the roles and powers of the speaker regarding the powers of disqualification, your lordship. The council would like to challenge the constitutionality of this powers and roles, your lordship, under three limbs. The first limb is that the speaker is still associated with the political party. The second limb is that he acts as a sole authority on deciding the matters of disqualification because of defection, your lordship. And my third ground is that there is only a limited scope for judicial review, your lordship. Your lordship, it is also pertinent to note that in paragraph 6 clause 2, it is stated that the disqualification procedure comes under the articles comes under the ambit of Article 122 and Article 212, your lordship. Under these articles, the court cannot interfere based on irregularity of proceedings, your lordship. The council would like to emphasize that the council is arguing for the constitutional validity and not the irregularity of procedures, your lordship. So this petition is well maintainable, your lordship. Now, moving on with my first limb of the argument, that the speaker is still associated with the political party, your lordship. A speaker was actually never intended to be a part of the political party, your lordship. This can be derived by analyzing the origin of the concept speaker, your lordship. The role of speaker and deputy speaker was originally originated in Britain, your lordship, where once a member is elected as a speaker, he is severed from all forms of political ties, Your Lordship. It is done in order to ensure an independent body to preside over the assembly, Your Lordship. And this practice is commonly known as once a speaker, always a speaker. He should no longer have any ties with any kinds of political parties, Your Lordship. This lays emphasis on the aspects of impartiality and independency of the speaker. But when we take the Indian context, Your Lordship, the role of speaker entered the Indian system through the Montagu-Chelmsford reforms of 1990. Here, the speaker is still associated with his political parties, Your Lordship. This may lead to partisan behavior or biased attitude on part of the speaker, Your Lordship. Even the Supreme Court has, in plethora of cases, reiterated the statement, Your Lordship. The council would like to cite the case of Jagjit Singh versus the state of Haryana, where which is found in page number 933 of the compendium, Your Lordship, which is stated that when acting upon the matters requiring impartiality, there exists a huge possibility of political overtone on part of the speaker, Your Lordship. The word
Now,
political overtone.
one more, Council, I think when you contest for the post of speaker, you denounce your party, right?
Your Lordship, the council is trying to convey that he must sever from all forms of political ties, Your Lordship.
That's exactly what he does when he contests as a speaker and gets elected as a speaker.
Your Lordship, the council would beg to differ. The council would like to state that he is still a part of the political party, Your Lordship, which forms even an iota of doubt which can cause an biased attitude or partisan attitude, Your Lordship, which may result in an enormous impact in the end, Your Lordship, as it is associated with the rights of not only the members of the Legislative Assembly, but ultimately rights of the people who he represents from his constituencies, Your Lordship.
Council, I don't think you're correct. If a person is to become a speaker, and when he becomes a speaker, he is no more a member of any political party. He is required to get out of his political party when he becomes a speaker.
Your Lordship, the council beg to differ that he will not resign his membership, Your Lordship. He will still be a part of the political party.
Okay, never mind. Go ahead.
Yes, Your Lordship. And in the case of Keshav Mahachandra Singh versus Honorable Speaker Manipur Legislative Assembly, the court suggested that there should be an alternative in place of speaker in form of an independent tribunal consisting of retired judges, Your Lordship. This was based this judgment was given on the basis of suspicion of bias on the part of the speaker, Your Lordship. Your Lordship, if Your Lordship is satisfied with this, the council would like to move on to the next limb of the argument. That is, the speaker acts as a sole authority in deciding these disqualification petitions, Your Lordship. As already stated, Rule 6 of the 10th schedule states that the whole defection procedure is vested with the speaker, Your Lordship, where the sole authority attracts conundrum in two aspects, Your Lordship. One is with regard to interpretation of the provisions, Your Lordship. The second one pertaining to the uncertainty on acting upon complaints. Now, coming to the first conundrum, that is with regard to interpretation of the provisions, as there is no other body to check the powers or check the role of the speaker is entitled to act even in an ambiguous manner, Your Lordship. In the case of Ravi S. Nayak versus Union of India, the court has observed that the speaker tends to take a narrow interpretation, an ambiguous interpretation, whereas a much clear interpretation is available in the statute, Your Lordship. This must be curtailed, Your Lordship. And coming on to my second contention, that pertaining to the uncertainty on acting upon complaints, the council would like to cite a few incidents in the country of Indigo, Your Lordship. In the state of Manipur, when there was no majority was achieved, member of Legislative Assembly from Indian National Congress moved to BJP in order to form majority, Your Lordship. In this incident, the speaker took no actions. In the state of Telangana, 26 MLAs from various parties moved to Telangana Rashtriya Samiti, Your Lordship. Even in these circumstances, no action was taken by the speaker. In the state of Andhra Pradesh, many MLAs moved from YSR Congress to Telugu Desam Party. Even 4 of them were appointed as ministers, Your Lordship. Even in these circumstances, no action was taken despite filing complaint for disqualification, Your Lordship. It is well known that the speaker cannot take action on his own, but he is obliged to act when a petition was filed in order to disqualify a person under defection, Your Lordship. Your Lordship, the council would also like to state that there can be no intervention from on the part of the governor, Your Lordship. It is stated in the case of Nabam Rebia versus the Deputy Speaker, Arunachal Pradesh Legislative Assembly. This leads to a chance of partisan behavior on the part of the overpowered and unchecked speaker, Your Lordship. Your Lordship, the council would like to move on to my third limb. That is, there is only a limited scope for judicial review. Initially,
Just
there
one
was no scope.
One moment, Counsel.
Much
Failure
obliged,
to failure to exercise or improper exercise of power by the speaker, is it a ground for annulling or declaring the law to be bad?
Your Lordship, the mere failure to act upon such complaints is not a ground at all, Your Lordship. But the ultimate effect of it, which affects the fundamental rights of the MLAs and the people, is the ground in order to declare this unconstitutional, Your Lordship, as the
Okay.
fundamental rights are violated in these circumstances.
You can stop sharing the screen.
Much obliged, Your Lordship. Your Lordship, moving on to my third limb of the argument, that is, there is only limited scope for judicial review. Initially, there was no scope for judicial review, Your Lordship, thanks to Rule 7 of the 10th schedule. But in the landmark case of Kihata Holahan, the Rule 7 was deleted and there was a limited scope for judicial review, Your Lordship. But it must be noted that the scope for judicial review is still limited, Your Lordship. And it makes it difficult to stop the actions, take down baseless allegations, take down colorable exercise of power, and even to prevent hasty decision, Your Lordship. Speaking of hasty decision, the council would like to state the case of Balchandra L. Jarkiholi versus B.S. Yediyurappa, where the court observed that the speaker tends to act in a hot haste manner, Your Lordship. This especially takes place when there is a motion to remove the speaker from his position, Your Lordship. Your Lordship, it is well known that the speaker can be removed from his position under Article 179 Clause C, Your Lordship, by passing an vote of majority. This requires an 14 days prior notice to be issued to the speaker, Your Lordship. This 14 days period enables the speaker to act upon the disqualification procedures in an unusual manner in order to take an undue advantage during the majority, Your Lordship, because the majority is taken only on the then present members, Your Lordship. So there is a possibility that the speaker may act immorally and remove remove many members on disqualification, Your Lordship, without containing actual examination or actual things, Your Lordship. This has been observed in the case of Balchandra L. Jarkiholi versus B.S. Yediyurappa, Your Lordship.
That's taken care of by judicial review.
Your Lordship, it is pertinent to note that the judicial review is available only after the finality of judgment, Your Lordship, only after the judgment has been passed. But when the speaker tends to act in such manner, which is against constitutional moralities, which is colorable exercise of power, must be addressed whenever it starts taking place, Your Lordship, or it will lead to grave danger, as delayed justice is denied justice, Your Lordship.
That's so in arbitration also.
Yes, Your Lordship.
You can challenge
Sorry, Your
any issue only after the final award is passed, even jurisdictional questions. So you can't strike down or declare a law to be bad only on that ground.
Thank you, Lordship. Your Lordship, but the court has observed that there must be some provisions in order to ensure that this is not happening, Your Lordship, because acting in a hot haste manner will remove him from his capacity at the time of defection, Your Lordship. So he will be considered as a defected member. So he will no longer be a member of the Legislative Assembly. He can't represent the interest of his people and all those stuff, Your Lordship.
Okay.
Your Lordship, the council would like to move on to issue 4. Through this issue, the council would like to most humbly like to submit that there exists sufficient measures to establish an independent, impartial machinery in place of speaker with regard to his power of disqualification, Your Lordship. Your Lordship, it is essential to note that the existing involvement of Election Commission in disqualification under Article 102 Clause 1 and Article 191 Clause 1, Your Lordship. This Article 102 Clause 1 and 191 Clause 1 deals with 5 kinds of disqualification, Your Lordship. That is, for holding an office of profit, being of unsound mind, declared insolvent, loss of citizenship, and disqualified by law, Your Lordship. Even in these circumstances, there is already involvement of President or Governor along with the consultation of Election Commission of India, Your Lordship. Election Commission of India, Your Lordship. The same can be applied to the provisions of Article 102 Clause 2 and Article 191 Clause 2, Your Lordship, which deals with defection, Your Lordship. But here, the power is solely vested with the Speaker, which attracts all these complexities and conundrum in these procedures, Your Lordship. Your Lordship, and the same has been recommended by 2 committee reports, Your Lordship. That is, the report of National Committee to Review the Working of the Constitution, issued in 2002, has stated that the role of Speaker must be replaced by the Election Commission, Your Lordship. And also in the 255th Law Commission report on electoral reforms, issued on 2015, also stated that the Election Commission must replace the role of the Speaker due to the partisan attitude shown by the Speaker, Your Lordship. Yes,
Also,
Your
law
Lordship.
commission report is only a recommendation.
Yes, Your Lordship, the council would like to have persuasive value on these recommendations, Your Lordship. Has the Law Commission report will consist of some elite personalities who analyze all these circumstances and come up with the recommendation after analyzing all the facts and circumstances involved, Your Lordship. It is pertinent to note, initially, when the anti-defection law was introduced, there was a necessity for the anti-defection law, Your Lordship, to curb and curtail the defections, which was in very all-time high, Your Lordship. After the defections coming into place, now these provisions are being manipulated and those loopholes are being misused by the representatives, Your Lordship. This must be curtailed. The law has become partially obsolete, Your Lordship. It fails to do its purpose, and it fails to curb the defection, Your Lordship. So there exist other provisions and other measures which can ensure that the anti-defection is done to the full extent, Your Lordship. Your Lordship, the speaker presides over the legislative assembly. He has grassroots level connection with the legislative assembly, Your Lordship. If that is the only concern, they can always resort to the parliamentary inquiry committees, that is parliamentary privileges committee and parliamentary ethics committee, in order to analyze on the facts and circumstances of that particular defection case, Your Lordship. It helps to make a much informed decision by the election commission also, Your Lordship. Your Lordship, speaking of the parliamentary ethics committee, the recent ethics committee report on MP Mahua Moitra is an apt example, Your Lordship. And by summing up all these things, Your Lordship, the council would like to convey that all the provisions of the 10th schedule, including paragraph 2, that is political will, paragraph 4, that is political merger, paragraph 6, that is roles and powers attributed to the speaker, all these are unconstitutional. All these are requested to be declared unconstitutional and ultra vires of the constitution, Your Lordship. The council would also like to quote a statement from the landmark case of Quixote Holohan versus Zachilio, Your Lordship. The court has observed that unprincipled defection is an evil in itself, but it is a greater evil when the remedy for it is graver than the disease, Your Lordship. By stating all these things, the council would like to conclude his arguments and move on to prayer, Your Lordship.
Yes.
Right.
Much obliged, Your Lordship. Wherefore, in the lights of the issues raised, arguments advanced, authority cited, the petitioners humbly pray before this honorable court to declare the 10th schedule as unconstitutional and or pass any order or orders as this honorable court may deem fit and proper in the interest of equity, justice, and good conscience. And for this act of kindness and justice, the petitioner shall be duty bound, and forever pray, Your Lordship. Lordship, it was an honor arguing before Your Lordships. Much obliged, Your Lordship.
Just one question to wind up. Tell me
Much
what
obliged,
happens if it's declared unconstitutional? What will be the situation?
Your Lordship, if the 10th schedule is declared unconstitutional by the Supreme Court, it applies all across the country, Your Lordship. So it applies both to the legislative assemblies and also to the parliament, and these things can be curbed, Your Lordship. And then the Honorable Supreme Court is entitled to issue a temporary or interim guidelines to act upon this, Your Lordship. But the council acknowledges that the judiciary cannot direct legislature to form a new act, Your Lordship, but the judiciary has the power to frame interim guidelines to act, interim guidelines to be in place till the new legislation is in place, Your Lordship.
No. You want defection to take place or not take place?
Your Lordship, defection should not be taken place, Your Lordship.
So when you remove the law that's existing, what happens? Anti-defection law is taken off. What happens?
Your Lordship, when anti-defection law is taken off, the Supreme Court is entitled to give an interim guidelines, Your Lordship. The same has been done in the case of Subhash Desai, Your Lordship. When there is an in the case of Subhash Desai, there exists a decision in Navamdebia, which is a 5-judge decision, Your Lordship. The court recommended that this decision must be reviewed by a 7-judge bench, Your Lordship. So for this period of time, the court issued an interim guidelines on how the defection must take place, Your Lordship. The same can be done in this very circumstances, Your Lordship. So the defection can be Your Lordship.
You didn't make any such prayer.
Your Lordship, the council stated that under
Okay.
or pass any orders. Much
all right.
obliged, Your Lordship, because an honor arguing before Your Lordship.
Thank
you, Lordship.
Thank you.
Suppose the Supreme Court of India issues guidelines, the parent judgments, but guidelines are given, which is land law. Judgment of the Supreme Court is the law of the land. Because suppose the parliamentarians do not follow, can they be hauled up in contempt before the Honorable Supreme Court under the Contempt of Court Act? Your argument is correct that 10 schedules should be removed from the Constitution.
Your Lordship, again, the council would like to rely upon Article 122 and Article 212, Your Lordship. The procedures of the Parliament must not be intervened by the court, Your Lordship, but only in the matters of irregularity of procedures, Your Lordship. But when a defection takes place, it challenges the whole of the morality of the defection and constitutionality of the defection. So, court can intervene in such circumstances, Your Lordship. It is till the legislature drafts a new bill in order to replace this, Your Lordship. Much obliged, Your Lordship. Thank you, Lordship. Lordship, if the council is of no more use to the court, the council would like to leave the podium, Lordship.
Yes.
Much obliged.
Before the respondents proceed, I would like to know how would they allocate their timings?
Right. As speaker 1, I shall be taking up 13 minutes. Speaker 2 shall be taking 16 minutes. And we shall be keeping 1 minute for sir rebuttal.
Yes, you may proceed.
May it please the court, the NGO Jan Seva has filed a petition against the Union of Indigo, and thereby we reserve the right to challenge the same, including its very maintainability. With the kind consent of the bench, the council would like to refer to your lordships collectively as honorable bench.
Yes.
Much obliged. The council seeks permission to share the comprehensive compendium given the size of the main compendium itself. And there are 4 issues. As the first speaker, I shall be dealing with the brief legislative history and issues 1 and 2, whereas my co-counsel shall be dealing with issues 3 and 4. With the kind consent of the bench, the council would like to deal with the brief legislative history and the provisions under Schedule 10 of the Constitution of Indigo.
Yes.
Much obliged. Talking about the brief history, in 1967, the Chavan Committee was formed that gave recommendations to curb the practices related to defections for the first time. And thereafter, we had 2 certain amendments to the Constitution itself. And in 1985, the Constitution 52nd Amendment Act was passed, which became Indigo's very first anti-defection law. It brought in amendments to the provisions of Article 101, Article 102, and Article 190, and Article 191 of the Constitution to provide grounds for the vacation of seats for the disqualification of members. And the 10th schedule that was inserted disqualified defecting members from the House, with an exception to splits and a merger. In 1992, we had the landmark Kyoto Holon versus Zachilu judgment that upheld the validity of the law. And in 2003, in light of the widespread criticism surrounding the provisions of 3 and 4, paragraph 3 and 4, the Constitution 91st Amendment Act of 2003 was passed, which omitted the provision related to splits or paragraph 3 from the 10th schedule. Having said that, I shall move on to a brief description of the 10th schedule itself. So the first paragraph talks about interpretation, wherein the concepts of house or the legislature party, they are discussed. And to talk about the legislature party, if we were to draw in a Venn diagram, then the legislature party forms a smaller circle within the political party, which is the bigger circle therein. Then para 2 talks about the grounds for disqualifications. Para 3 talks about the splits, which was removed by the 91st Amendment Act of 2003. Para 4 talks about the exemptions for merger. Para 5 talks about the exemptions for the speakers. Para 6 talks about the decision of the chairman or the speaker, which shall be dealt to be final. Para 7 talks about the bar in the jurisdiction of the court. And para 8 talks about the rules that can be made by the speaker or chairman. With the kind consent of the bench, the council would like to move on to the first issue, thereby challenging the maintainability of the petition, as it seems that the learned friends themselves are confused because they're trying to establish the maintainability even at this stage. Shall I proceed?
Yes, yes.
Much obliged, on bench. The councils for the state humbly submit that the present PIL is driven by publicity interest. The Honorable Court in the Janata Dal case of 1992 clearly warned us against the misuse of public interest litigations by busybodies or meddlesome interlopers, as has been rightly upheld in the Ashoka Kumar Pandey versus State of West Bengal case in 2003, which can be seen in the next case, wherein the Honorable Court held that the public interest litigation, which have now come to occupy an important field in the administration of law, must not be publicity interest litigation or private interest litigation or, Honorable Bench, politics interest litigation. If not properly regulated and abuse averted, it becomes a tool in unscrupulous hands to release vendetta and wreak vengeance. It was also mentioned that a mere obsession with a personal philosophy cannot be regarded as a legal disability, Honorable Bench. Therein under, as stated in Maneka Gandhi versus Union of India, if something is just, fair, and reasonable, then the mere reason of it having loopholes or a chance for the same to be misused does not render it invalid or perhaps unconstitutional, as our learned friends have been stating, because that was stated in Indra Sawhney versus Union of India. Further, applying the rule of stare decisis, the case of Subhas Desai versus Governor of Maharashtra and Kyoto Holuan versus Zachilu in 1992, alongside the rule of res sub judice, where the matter of Prithviraj Meena versus Honorable Speaker is already going on in this very court.
Counsel, can you tell me about the principle of stare decisis?
Yes, the principle of stare decisis talks about if something has already been decided by the court itself, that has to be followed therein under. And that has been upheld twice, Honorable Bench.
Just a precedent.
Not precedents, anything that has been stated by the court of the highest order, or any courts below it, and that will be applicable under them.
Where the law has been settled over a long period of time.
Yes.
Okay, go ahead.
Much obliged, Honorable Bench. Further, it seems as if the petitioners wish to waste the resources of this court and thereby renders it not maintainable. If you were to also look at the written submissions of our learned friends, we find that they have cited the case of P.V. Narasimha Rao versus State of 1998. However, the same is under ongoing reconsideration in this very court under a 7-judge bench consisting of His Lordship Chief Justice of India D.Y. Chandrachud himself. If your lordships have no further questions, I shall be moving on to my next issue.
No, they are raising a valid point because there has been a misuse. So they are trying to see how it can be remedied. So it's an important issue. Why shouldn't this court consider?
Because, Honorable Bench, the courts have firstly dealt with this.
The Article 32 is there.
Yes, Honorable Bench.
It can address questions of this nature.
Yes, Honorable
Unless you are able to demonstrate they have an oblique motive. Correct? And just by saying publicity, that will not be good enough. Is there anything specific? Is there a history? Is there a precedent of this petitioner or this the body having abused its PIL jurisdiction earlier?
Honorable Bench, we had already mentioned the same in. If you would kindly move ahead with the issues, kindly share the compendium. Rishibi, you're sharing the screen. Yes. Yes. Moving on to I'll talk about the same, Honorable Bench. Because we have already dealt in the Subhas Desai case that the same has been talked about by the court itself. And therefore, it has already been dealt with several other cases which my co-counsel should also be bringing in front of this Honorable Bench. And to talk about, if the court would allow me to move ahead with the second issue, I shall come to the points as well, which have been mentioned here and under.
You have to satisfy us on the first issue. Just by stating that it's public interest, publicity oriented, that doesn't suffice. You didn't say anything as to why it's not maintainable beyond publicity.
Right, Honorable Bench. Because we have it was recently held in Subhas Desai case only. It was in 2002 June that the Honorable Bench had mentioned the same, or rather held brought in a decision on the same. So them bringing the same thing again and again, it only seems as if
same issue has been brought in by an earlier petition by somebody else. Is what you're saying?
Yes, Honorable Bench. And the court has already decided, and there it has been multiple judgments on the same. Then under the same judgment talking about the removal of the entire Article 10 or Schedule 10 without bringing certain amendments if they wished for the same. That is what we are talking about, Honorable Bench. The removal of the entire will render it a lot of problems later on.
All right.
Much obliged. Moving on to my next issue, whether the anti-defection law exhibits notable deficiencies concerning the element of voters' trust, thereby necessitating amendments. As again held in Indra Sawhney versus Union of India, if something might have loopholes or perhaps can be misused, that does not render it invalid or unconstitutional. Further, the Council would humbly submit the exception to the anti-defection law under paragraph 4 applies only when 2/3 of the members of a party merge with another party. The provisions on merger uphold the intent of the legislator's freedom of expression. The Kyoto Holuan judgment has held mergers to be a substantive faction of a party, to be a part of the political process itself. And the legislature has made a presumption of bona fide based on the existing standards of political morality, thereby expressing the legislative wisdom. If there are no questions, I shall be moving on to my next sub-issue.
Okay.
Much obliged. Coming to the next sub-issue, that is where the aspect of split or paragraph 3 and why it was removed. Splits were used when 1/3 of the party split from the original party, and the provision of split prevented them from being disqualified. However, the misuse of the same has been noted by this court in several judgments, wherein it was mentioned that the line between split and defection was a very thin one. If we were to talk about the case of Ravi S. Naik versus Union of India, the evil of political defections has been a case of national concern. And with the object of the anti-defection bill as it was then, and assurance was given by the government, and the same has been kept by the government till date. And the same was upheld in the cases of Rajendra Singh Rana versus Swami Prasad Mori and several other cases. Post this, the provision for split was finally removed, and rightfully so, in the 91st Constitutional Amendment in 2003. If there are no questions, I shall be moving on to my final sub-issue.
Okay.
You want to say that there should not be any defection at all.
Defections on the basis of merger, they may happen, because that implies that the political process in the nation is shifting, and that is something that we respect and value. However, splits were mostly done on the very nature of ensuring that, the majority party becomes a minority party, or that caused instability in the government. So to reduce the same, that is why, because there were 68 splits in the year 1990 to 2004 itself, as has been seen in the statistics itself. So thereby, to reduce the same, the concept of splits was removed, but mergers, which talked about 2/3 of the party, since that was a big faction, and that ensured that perhaps the political process or the thoughts of the members of the party themselves were changing, and that indicated the nation at large, and they were representatives of the people at large. Thereby, we have kept the Constitution Amendment has kept the provision of mergers, or para 4. If you're not, shall I proceed with the next sub-issue?
Okay.
Much obliged, Your Lordship. Coming to my final sub-issue, that the Commonwealth democracies have widely accepted the provisions of merger as submitted, or maybe humbly submitted, the Commonwealth democracies like that of South Africa. If we were to move to the next page, we find South Africa in Schedule 6A, we find Ghana in Article 97, Clause 2, and Nigeria in Constitutional Article 68, 1G and 109, 1G talk about, or rather they have provisions dealing with the merger of political parties. Drawing global comparisons with states from similar frameworks, as seen in Shaira Banu case itself, it is humbly submitted that Para 4 is an exception to the provision of defection and therefore must stand. With that, I shall request my co-counsel to move on with the issues 3 and 4. And that was all from my end. If your lordships have any questions, I would be glad to answer the same.
I think the council should remember, you shouldn't be so overwhelmed by the time limit. It's better to present any point that you're presenting with clarity than rushing through a point. Even if you don't complete it, it's okay. If we are judging you how well prepared you are or how you're able to respond. So take your time, respond to the queries. Don't be in a rush, because that doesn't help you. You're neither making this point nor that point.
Yes, Your Lordship.
Okay, you can proceed.
Much obliged, Your Lordship. It was a pleasure arguing in front of this bench. Thank you.
May it please the court. This is the second counsel on behalf of the respondent, and I shall be dealing with issue 3 and issue 4. As my learned co-counsel has already established the constitutionality of the provision under paragraph 4 of the 10th schedule. Honorable Court, before I move on to my issues at hand, I would like to clarify a few points, because all the submissions of my learned friends on the opposite side ultimately culminate in their very prayer, that is declaring the entire 10th schedule of the Constitution to be ultra vires, and because it violates the basic structure doctrine in itself. That is to say, they are suggesting that for now there shall be no anti-defection law in the state of Indigo. Honorable Court, if I may refer to the doctrine of pith and substance and try to analyze the true nature of the legislation, that why the 10th schedule was inserted in the first place. What was the legislative intent behind enactment of the 10th schedule? That was to strengthen the parliamentary democracy, which is a part of the basic structure doctrine. And how? By curbing unethical political defections.
Honorable Court, if I am to summarize the submissions of my learned friends in crux, then there are three basic points they have made. Firstly, that the freedom of speech and conscience of the legislator is being violated under the whipping system. Secondly, mergers may be misused to evade disqualifications. And thirdly, giving the speaker enough power to adjudicate disqualification proceedings raises suspicion of biasness. Honorable Court, I am forced to ask this question to myself at this juncture, that are we at all analyzing the constitutionality of the 10th schedule through this petition? Why we mentioned that this petition does not concern any substantive question of law? Are we at all dealing with any question of law? Or are we again faced with the question of construction of the 10th schedule, which was rightly observed by Justice Venkatacharya in paragraph 8 of the Kyoto Holohan judgment, where the court has upheld the entire validity of the 10th schedule. Honorable Court, with this, the Council would like to proceed to analyze the provisions of the 10th schedule, thereby trying to establish that how proportionality has been imbibed in each and every paragraph of the 10th schedule, ensuring checks and balances such that the Wednesday principles of reasonableness are upheld, which is to be analyzed in any case of judicial review. This, Honorable Court, I move on to my first issue, that is whether the norms of the Westminster system of parliamentary democracy. Honorable Court, the Council here would like to state, as my opposite party mentioned about constitutional morality. So what is this constitutional morality according to Dr. B.R. Ambedkar himself? He mentions that constitutional morality means that it would boost confidence at the bosom of every citizen amidst the bitterness of party contest, that the forms of constitution will not be less sacred in the eyes of the opponents than his own. That is, the constitutional ideals should be valued and understood by all organs of the government equally and respectfully. With this, if I may read out paragraph 21B of the 10th schedule, Honorable Court, it talks about the fact of disqualification, that if the voter votes or abstains from voting in such house, contrary to any direction issued by the political party to which he belongs, or by any person or authority authorized by this behalf, then he shall be disqualified. This has to be read with Rule 2F of the Lok Sabha defection rules and other state assembly rules, which talks about who is the leader of the political party. And this provision essentially means that if a whip has been issued and the member votes contrary to it, his position go away as a member of the parliament or legislative assembly, whatever. Honorable Court, the intent behind insertion of this provision was, number one, to maintain discipline in the House. Number two, to streamline its proceedings. And in the matter of policy implementation, the larger interests of the public should be upheld. This is a matter of public policy, and it has been held or observed in the case of Kuldeep Nair, S.R. Bomai, Kyoto Holohan, and so on and so forth. If I may refer to the case of Kyoto Holohan versus Achilo itself, it mentioned that in a multi-party system, the shared beliefs of the political party creates a public image and confidence, and the entire existence of the political party is based on its ideology. Moving on to the latest judgment of Subhas Desai versus Governor of Maharashtra in the next slide. This judgment essentially upheld what was held in Kyoto Holohan judgment. In 2023, it was held that the legislator should not be allowed to sever the umbilical cord he has with his political party, because that they could appeal to the voters on the basis of their affiliation with the party, but that they can later disconnect themselves entirely from the very party and able to function as a separate group of MLAs that no longer owes even a hint of allegiance to the political party. Deciphering the legislative intent even further, if I may move on to the next case, that is the very origin of the anti-defection law. This is a case of the King's Bench in the United Kingdom, Bradlaugh versus Gossett. It talks about the fact that the parliament should have the power to control its own proceedings or regulate its own proceedings. Honorable Court, moving on, the next submission that has been raised is that this law violates the freedom of speech and expression of the legislators.
Council,
Honorable-
one moment.
Yes.
One moment. You are taking us through the legislative history. Tell me,
Yes.
why should any provision be made for defection? This is a case of merger, so then there's no defection. If you want to prevent defection, why not completely ban defection? What's the logic for not providing for no defection, not providing for it?
Indeed, Honorable Court. So, as my co-counsel already mentioned, that this very recommendations were made by various committees. But as your lordship only previously mentioned, that these are merely recommendations. But what the legislators or the legislature chose for itself was to keep the provision of merger. The council has mentioned it in the written submission that this ensures a proper balance between the freedom of expression of the members of the Legislative Assembly and along with that, the political process of the country. Because the same has been held in the case of Golaknath as well, that the popular sovereignty and the equality right must be balanced in such a way that both are upheld. So it is a submission that by keeping one provision for merger, and not only for merger, Honorable Court, there are exceptions for the nominated members, there are exceptions for the speakers for that matter. So through all these things, proper checks and balances, as I already mentioned, has been ensured. And if I may add on further to the point of freedom of speech and expression that I was referring to, Honorable Court, paragraph 2(1)(b) has a provision that the member of the political party, if he or she wants to vote contrary to the direction given by the political party, he may apply 15 days prior and obtain the consent of the members, of the leader of the political party or the authorities concerned. Along with that, Honorable Court, it is very difficult to conceive how Article 105 could provide an immunity from the consequences of unprincipled floor crossing, Honorable Court. So, freedom of expression should not be seen as an immunity to such unethical practices. Also, Honorable Court, Article 105 merely bars the jurisdiction of the court when a member has spoken something in the legislature. This is the main intent, that no judicial intervention, as was held in the case of H. Kiran Jain versus N. Sanjeeva Reddy, and also various other cases like the Kyoto Holohan versus Achilu judgment. Now, if I may proceed to my next sub-issue, that is, it is also argued that these party directions, they do not serve any constitutional purpose, but rather they are mechanisms to promote intra-party discipline, that is discipline in the political party. Next page, Aditya. So this Honorable Court has already held and clarified in the case of Subhas Desai versus Principal Secretary that political party and legislature party are not one and the same. Legislature party is defined under paragraph 1(b) of the 10th schedule, whereas political party has been defined under section 2(1)(f) of the Representation of the People's Act. So, if through these provisions, the members of the legislature party are kept under abeyance, then there is no question of unfairness on part of the provision because it stands the test of reasonableness, Honorable Court. So, if the court is satisfied, then I shall be moving on to the last issue that the councils have.
Yes.
Much obliged, Honorable Court. So the last issue consists of the question that whether certain regulations pertaining to the proceedings of disqualification are called for. Honorable Court, under this, the main submission was that since the speaker is the adjudicating authority, he can, in some instances, be biased, number one, and as a corollary to it, it has been established that certain independent tribunals should be made into the adjudicating authority. Now, Honorable Court, over here, if we look at the table of precedents in the structure of democratic structure of the Republic of Indigo, then the Speaker of Lok Sabha is placed on the equal footing as the Honorable Chief Justice of Indigo. So we are questioning the authority of such an institution along with the speakers of the state legislatures. Honorable Court, if we are to look into the if we are to look into the reasonableness of the proceedings, that how these disqualification proceedings are undertaken by the Honorable Speaker, it is done by the members of Lok Sabha disqualification on grounds of defection rules formulated under paragraph 8 of the 10th schedule. Now, what does these rules mention? These rules mentions, for one, that the Speaker does not alone have to adjudge the question of disqualification. He can appoint any number of committees to inquire into the facts. Also, he has to abide by the principles of natural justice, that being odi alteram partem, that the disqualification proceedings, again, whichever member is going on, he has to be given an opportunity to be heard. Checks and balances, Honorable Court. So here again, the council submits that these rules must be upheld, and also in the Halim Committee report, this issue was dealt with in detail, and it has been said that if now another independent body is now made into the body to adjudicate matters of the parliament, it will further increase the complexities with regards to separation of powers and so on. So if the council may be allowed to refer to certain judgments regarding this very nature of biasness of speakers, then in Balachandraji Jharioli versus B.S. Yadurappa, it has been mentioned that the biasness has to be analyzed from the point of view of a reasonable, objective, and informed person. However, I would like to rather emphasize on the judgment of Jagjeet Singh versus State of Haryana, 2006 judgment. The same question arose regarding whether or not the speaker is an impartial authority. The court rightly held that mere allegations of malafide intention on part of the speaker does not invalidate his constitutional position as a high parliamentary authority, number one. Number two, court explicitly mentioned that the parliament only can decide if an independent body should be made into an adjudicating authority. Again, in Srimad Balasaheb Patil versus Honorable Speaker 2019 judgment, the court again held that the speaker adjudicates with the highest traditions in constitutionalism, and the court may aid the speaker to come to a conclusion. Honorable Court, this brings me to my very last submission, that even the proceedings under the speaker are not amenable to judicial review. That is to say, as it was clarified in the case of Kyoto Holohan versus Achilu, that there are two parts of it, the substantive part and the procedural part. If we are to look at the substantive part, when can the judiciary intervene? When there is malafide or violation of constitutional mandate, non-compliance of principles of natural justice, perversity, and so on. This is the substantive part where judicial review of speaker's orders is allowed. When it comes to the procedural part, under Article 122 and 212, despite the immunity that is being provided, in Subhas Desai judgment, it has been upheld in 2023 Honorable Court that if the procedure violates the democratic functioning of the parliament, then also the court may intervene. Honorable Court, if we are to look at the anti-defection laws throughout the world in other Commonwealth democracies, then out of 55 countries that have experience with it, 35 countries have got no anti-defection law in existence. On top of that, Honorable Court, the constitution or anti-defection laws of Mozambique, Malawi, New Zealand, Belize, Lesotho, all these countries provide no scope for judicial review, whereas our anti-defection law has got provisions for checks and balances whereby the decision or order of the speaker can be challenged in the court as well. And moving on to the last submission on part of the council, that this very question of judicial review has been held in the Standing Committee report of 2013. Next slide. Over here, it has been observed by the Election Commission that unless the principles mentioned in Kyoto Holohan versus Achilu are violated, the court should not question about the biasness of the speakers or should not question into the procedures of the parliament, because it violates the supremacy of the legislature and the long-standing theory of separation of powers. Yes. So with this,
Okay.
the council would like to end her submissions and move on with a very short prayer if the court may allow.
Okay, your contention is that the Schedule 10 of the Constitution should remain, number one. Number two, you
Yes.
also suggested that to have regulations to control the speaker and to restrain the defection. But regulation is nothing but a delegated legislation. Regulations are nothing but delegated legislation. So can the delegated legislation override the subsisting the provision that is Schedule 10 of the Constitution of India? One. Number two, you also suggested tribunals. You feel that a tribunal will be in a position to control this particular aspect concerning the defection in parliament or in state assemblies.
Much obliged, Honorable Court. I think I have not made myself very clear during my submissions. Honorable Court, the Council did not suggest any regulations that would take place on the Speaker's orders or decisions. The Council merely wanted to establish the fact that judicial review that is allowed for Speaker's decisions must be restricted because of the doctrine of separation of powers that exists. It was a submission on part of my learned friends on the petitioner's side that tribunals must be established in order to adjudicate, but the respondent state submitted that no tribunal should not be established, but rather the speaker's authority under the 10th schedule read with the associated rules of the legislative assemblies or Lok Sabha, they should be allowed to govern the entire process of disqualification, Honorable Court.
So that's the reason you are basing reliance on the recommendation of the election commissioner. There should be
Yes.
some restraint and checks and balances in exercise of power by the Supreme Court under Schedule 10.
Indeed, Honorable Court. And this very thing has been held by this court in Tihotoholohan versus Achilu judgment as well, regarding the sanctity of the office of the Speaker and also the separation of powers as the Council submitted.
Okay, the council,
Yes.
tell us, we are seeing so many transgressions and so many cases coming to the court,
Indeed.
and that gives an indication that there are some shortcomings in the existing legislation.
Yes.
So what should be the remedy for that?
Indeed, Honorable Court, the petitioners have failed to establish what exactly pinpoint the exact problem with the anti-defection law, because the respondents have tried to clarify that all the provisions of the law are just fair and reasonable, and just because there are certain loopholes, that does not mean that the entire law should be declared unconstitutional. If the exact pinpointed portion of which part of the law is violating some certain fundamental rights or whatever the parliamentary democratic procedure, then it holds no value. This submission holds no value. And Honorable Court, in the case of MSM Sharma versus Sri Krishna Sinha, it has been held that in the matters of parliament, the court has no jurisdiction to consider whether a person has committed a breach or so on. So again, the concept that I already mentioned, that is being reiterated, that if there is some breach, of course, the judiciary can come in and the judiciary can uphold this case-to-case basis, on case-to-case basis. But if there is a question of law, the council submit that there is no loopholes in it.
So according to you, there are no loopholes in the existing law.
Indeed not, Honorable Court. The law should remain as it is.
Okay. Thank you.
Much obliged. Much obliged, Honorable Court.
He said that the rebuttals are at the discretion of judges. So I would like to ask the bench whether to continue with the rebuttals or not.
Yes, let them.
Yeah. The petitioners, you may proceed with the rebuttals.
Lordship, the council seeks permission to move on with the rebuttals.
Go ahead.
Much obliged, Your Lordship. The Lordship, the respondents have stated that the 10th schedule have been held constitutional in the past, Your Lordship. The council would like to state that the mere reason that it has been held constitutional in the past cannot be a ground in order to curb the challenge of constitutionality, Your Lordship. The council would like to state the case of Joseph Sain, which is a very landmark famous case, Your Lordship. This case was declared constitutional 3 times prior declaring unconstitutional, Your Lordship. So, mere declaration of constitutionality by a court cannot bar another party from approaching the court challenging the constitutionality, Your Lordship. And the council would also like to state that they have referred to the case of.
Doesn't it become a binding precedent?
Your Lordship, indeed, yes, Your Lordship, it is a binding precedent, Your Lordship. But if there are any other infirmities, or if there are any other violation of fundamental rights, the aggrieved party is entitled to approach the court and seek remedy, Your Lordship. It cannot refrain them from approaching the court itself, Your Lordship.
The case which you cited, what were
Yes,
the
Your
facts? What was the difference that was pointed out for holding it unconstitutional for in the fourth round?
Your Lordship, the Joseph Singh case was regarding the adultery, Your Lordship, which is built in section 497 of the IPC, Your Lordship. Here, the court held that this adultery must be struck down as it violates the fundamental rights of Article 14, Article 15, and Article 21, Your Lordship. Before this, only men were punished for adultery and women were not punished, Your Lordship. So the court held that the respondents have stated that no one should be punished for adultery and the whole provision was struck down, Your Lordship. The earlier decisions of the court differed from this, Your Lordship, but later the court arrived to this decision, Your Lordship. So the mere declaration of constitutionality by a prior court cannot curb the entitlement of the of another party to approach the court itself, Your Lordship. And the respondents have stated that. Yes, Your Lordship. Yes, Your Lordship.
In such a circumstance, it has to be referred to a larger bench before it can be overruled. Correct? We'll have to persuade the bench to say the earlier decision has failed to notice certain things, and therefore it should be referred to a larger bench. Okay, go ahead.
Lordship, then the respondents have stated that the mere chance to misuse a loophole cannot be a ground for challenging the constitutionality, Your Lordship. The council would like to reiterate that there is no mere existence of loophole, Your Lordship. The loopholes are being misused, being exploited, and it results in the derogation of fundamental rights, Your Lordship. And the council would like to reiterate the same by stating the doctrine of merger, Your Lordship. The respondents have stated that, yes, Your Lordship.
The point the council made was, you have not pointed out specific loopholes.
Yes, Your Lordship. If you, with the permission of Your Lordship, the council would like to pinpoint the exact place, Your Lordship. Your Lordship, in the doctrine of merger, 2/3 of the majority is required, Your Lordship. And in order to ensure this, the three tests that are given by the Sadiq Ali versus Election Commission of India are test of majority, test of aims and objects, and test of party constitution, Your Lordship. If Your Lordship's permit, the council would like to share screen, Your Lordship.
No, that's okay. You are in rebuttal. It's fine.
Yes, Your Lordship. The court has held that only the test of majority is a valid and useful test, Your Lordship. The court ruled out that other two tests are proved to be inefficient, Your Lordship. So the whole system has to rely only upon the test of majority, Your Lordship. While relying upon the test of majority, the merger is decided merely by the legislature party, Your Lordship. So there is a possibility that the legislature party can be very small. Yes, Your Lordship. Very small, Your Lordship. So, for instance, as my co-counsel have already stated, if the legislature party consisting of only 3 members, the mere majority of 2 members can allow a merger, Your Lordship. And it is not necessary that the original party must have done a merger, Your Lordship. The mere merger by the legislature party itself grant protection, Your Lordship. So there is no actual intent to create a merger by the original political party, but the person, that is the minority persons representing the original political party in the legislature party, only by means of their intention, they are creating a merger, Your Lordship. It is not at all the intention of the original political party, Your Lordship.
Misuse can be addressed by the court. Why should the legislation be struck down?
Your Lordship, much obliged, Your Lordship. By stating this, as my co-counsel have already stated, the right to elect is a fundamental right, Your Lordship. So the right is being violated, Your Lordship. The people are elected in order to represent the interest of the people of that certain constituency, Your Lordship. When defections like these happen, the main motive behind these election of these representatives changes, Your Lordship. That is the reason for addressing this, Your Lordship.
Okay.
And yes, Your Lordship. Now, coming on to political whip, they have stated that the political whip have proper balances and is reasonable, Your Lordship. But the political whip says that any direction can be issued, Your Lordship. This scope is very vast and very ambiguous, Your Lordship. And the council have not only placed allegations, the council have already pinpointed few instances, Your Lordship. The instances that happen in Manipur, happen in Andhra Pradesh, happen in Telangana, Your Lordship. The council would also like to state that, Your Lordship. And the final contention of the respondents was that the judicial review must be restricted, Your Lordship. the restriction of the judicial review is the sole basis for deletion of paragraph 7 in the initial Kyoto Holohan case, Your Lordship. So the same cannot be relied upon now. Cannot be relied upon now, Your Lordship. There must be sufficient judicial review in order to ensure the safe functioning of the Speaker, Your Lordship, which is not in the present case, Your Lordship. The Council would like to reiterate this and like to conclude this argument and like to rest the case in hand, Your Lordship. Much obliged, Your Lordship.
Thank you.
The
Thank
other
you.
side pointed out that
Much obliged, Lordship.
you have not pointed, you have questioned the entire Schedule 10.
Much
But you
obliged,
have not pinpointed which portion of the Schedule 10 to be struck down.
Your Lordship, the Council would like to pinpoint 3 exact questions, Your Lordship. First is the doctrine of political whip, where the scope of the doctrine of political whip is vast and ambiguous, Your Lordship. So the original political party can misuse these representatives. The representative is not merely a representative of political party. He is the ultimate representative of people of his constituency, Your Lordship. This is misused here, and he is merely used as a rubber stamp, Your Lordship. The second provision is that paragraph 4, Your Lordship, that is doctrine of merger. Here, the doctrine of merger, in cases of small parties, is being misused, Your Lordship. As there exists only one test which is valuable, that is the majority test. This test is also proven ineffective in order to determining merger in case of smaller legislature party, Your Lordship. So all the smaller smaller legislature party misuse these provisions by the legal fiction of deemed merger, Your Lordship. It is immaterial whether the original political party merges with the another original political party, Your Lordship. The mere intention of the legislature party itself provides the protection, Your Lordship. It is the issue to be addressed here, Your Lordship. And again, to further state, the paragraph 6, Your Lordship, which grants unchecked power to the Speaker, Your Lordship. These are the 3 main points that the petitioners like to pinpoint, Your Lordship. Much obliged, Your Lordship. Your Lordship, if the Council is of no further assistance, the Council would like to rest the case in hand, Your Lordship. Much obliged, Your Lordship. It was an honor arguing before you.
If the council may be allowed to respond to the contentions.
That's fine. That's
Honorable
fine.
Court.
Not required. Thank you.
Okay. Okay. Much obliged.
Thank you.
Before we conclude the session, I request the bench to send the score sheet to the respected email ID and provide any feedback for the participants for the further advancement of the rounds.
Fine. We'll do so.
Okay.
Yes, little bit of advice for all the participants. Look, I know you all have worked hard, prepared harder, and trying to give your best presentation. But just keep in mind that what can we judge in this 15 minutes of your presentation or 16 minutes or whatever be the presentation is, to understand how well you have understood and how clearly you're making a point. Correct? Conceptually, are you clear? So keep that broader principle in mind. This may be one mood. They'll be participating in many moods. So keep the broader principles in mind. I will state a point. I'll make that point good. And you'll have to show us that you have understood the point that you're making. If you don't know the answer, you should know how to deal with the question. It's not necessary that you will know the answer to every question that we ask, but you should still be in a position to know how to deal with the question for which you don't know the answer. And that will happen as you start practicing also. But it's always good to keep your composure, keep calm, explain what you have understood, what you think is the point, and make good that point. See, out of the 4 points, 2 year split or whatever you've done, even if you presented 1 point in that 15 minutes very well, that's what we are going to judge. What you have missed out, we'll never know. We are talking about what we are hearing, correct? Of course, in the written submissions that will be gone through, or your presentation which you have given, that will be evaluated separately, I guess. So therefore, that will have the marking for that. So just be calm, cool, composed, and give clear answers. If you are not knowing the answers, that's the only time when you'll evade, but you'll have to evade it smartly. Okay. All the best. You all have done very well. Good luck to you.
Yes, I'm very impressed. Everybody has done very well. And you have to only learn the art of advocacy that my learned brother has spoken. That is very, very important. This academics in the universities will not help you to become a very good lawyer. You also learn the art of advocacy, and that you will get only from the office where you join as a junior. All the best.
Thank you, sir. It was an
Thank
honor
you.
to have you.
Thank you for this kind words, Your Lordship.
On behalf
I thank Deepak Bhattacharjee sir and Basava Prabhu Patil sir for adjudicating these rounds and for giving us time out of their valuable schedules on a Sunday for coming forward and adjudicating these rounds. Thank you so much, sirs, for joining this year.
Pleasure. Thank you.
We are also obliged.
Thank Sir, I request the court masters to remove the speakers from the room. Court masters, you can stop recording.